The following program is for informational and educational purposes only. Please seek legal counsel if necessary. Thank you everyone for joining. Appreciate your time and energy. So we're going to be reading a article on the Evanston Reparations lawsuit, and we're actually going to be reading the lawsuit itself. So let's get into it. Class action suit claims city's reparations program is unconstitutional. A group of plaintiffs, supported by a conservative group, filed a class action lawsuit Thursday, claiming the City of Evanston's local reparations program is purposefully and intentionally discriminating against them and potentially tens of thousands of others by limiting eligibility to Black recipients in most cases, which they say constitutes a violation of the Equal Protection Clause of the U.S. Constitution. In a 9-page complaint filed in U.S. District Court, the 6 named plaintiffs, Margaret Flynn, Carol Johnson, Stasis Neimanas, Barbara Rigard, Henry Rigard, and Stephen Wayland, say they are each descended from people who lived in Evanston from 1919 to 1969, but aren't Black, precluding them from qualifying as, quote, direct descendants, end quote, in the city's restorative housing program. They allege this requirement racially discriminates against them and that without it, they could be eligible for and in line to receive $25,000 under the program. Plaintiffs are being irreparably harmed by defendants, the city's deprivation of their rights to equal protection. The complaint reads, plaintiffs remain able and ready to apply for payments under the program and intend to apply if the race-based eligibility requirement is declared unconstitutional and enjoined. In the lawsuit, the plaintiffs ask that the requirement be struck down as unconstitutional and the court award payments of $25,000 each to them and other members of the lawsuit's class, defined as anyone who qualify for reparations program, quote, before the program's race-based eligibility requirement, end quote. They estimate this class is they estimate this class to number in the tens of thousands, if not more. It looks like this is the second time Judicial Watch sued the City of Evanston over the reparations program. Another lawsuit regarding public records was filed in Cook County Court shortly after the program started in 2021, but it was dismissed a few months later. Thanks once again for joining. If you have a chance, please like, share, and subscribe. And also, if and when you do go shopping at Amazon, hit that affiliate link to support what we're doing. So let's read the class action complaint. In the United States District Court for the Northern District of Illinois, Eastern Division, Margaret Flynn, Carol Johnson, Stasis Neimanas, Barbara Rigard, Henry Rigard, and Stephen Wayland are the plaintiffs versus the City of Evanston as the defendants. Class action complaint. Plaintiffs Margaret Flynn, Carol Johnson, Stasis Neimanas, Barbara Rigard, Henry Rigard, and Stephen Wayland by counsel and pursuant to 42 U.S.C. 1983. Section 1983 provides an individual the right to sue state government employees and others acting under color of state of law for civil rights violations. Section 1983 does not provide civil rights. It is a means to enforce civil rights that already exist. Also, please stay to the end because we're going to be going over some of these terms and definitions, and I'll also be putting the link or the description of some of these cases that we're going to be going over. That's in this case in the description as well, and you can do your further research. Thanks. Bringing this class action lawsuit challenging on equal protection grounds defended City of Evanston's use of race as an eligibility requirement for a program that makes $25,000 payments to residents and direct descendants of residents of the city 5+ decades, if not more than a century ago. Plaintiffs seek a judgment declaring defendants' use of race to be unconstitutional. Plaintiffs also seek an injunction enjoining defendant from continuing to use race as a requirement for receiving payment under the program and request that the court award them and all class members damages in the amount of $25,000 each. Jurisdiction and venue. The court has jurisdiction of this lawsuit under 28 U.S.C. 1331 and 113 and 134A3, and 2, venue is proper under 28 U.S.C. 131B2. Parties. Plaintiff Margot Flynn is at least 18 years of age and is a direct descendant of Evanston residents. Plaintiff Flynn's parent and grandparents lived in Evanston between 1919 and 1969 and were at least 18 years of age at the time. Plaintiff Flynn does not identify as Black or African American, nor did her Evanston parents or grandparents identify as Black or African American. All right, it looks like the same wording is going for the plaintiff Carol Johnson. And it looks like the same wording is going for plaintiff Stasis Niemanas. Looks like the same wording is for Barbara Regard. And the same wording is for plaintiff Henry Regard. And looks like that's points 3, 4, 5, 6, and 7. All right, move on. Looks like the same is for plaintiff Stephen Wayland. And that's point number 8. All right, number 9. Defendant City of Evanston, quote, Evanston, end quote, or, quote, the city, end quote, is a general purpose municipal government located in Cook County, Illinois. It is a home rule unit as defined in the 1970 Illinois Constitution. Factual background, point 10. Through a series of resolutions adopted by the Evanston City Council, Evanston has created a program to provide $25,000 in cash payments to residents who lived in Evanston between 1919 and 1969 and their children, grandchildren, and great-grandchildren. The program, entitled City of Evanston Local Reparations Restorative Housing Program, uses race as a requirement for receiving payment and purports to remedy housing discrimination experienced by Black and African American residents 55 to 105 years ago. The city committed an initial $10 million to the program at the time it was created. It committed an additional $10 million in November 2022. Following an initial set of applications, further applications will be accepted on a rolling basis. At no point has Evanston asserted that the program is closed. As part of the application process, applicants are required to state whether they and their ancestors identify as Black or African American. The first group of persons eligible for $25,000. Is that right? Okay, so there's 4 zeros there. But okay, anyway. The first group of persons eligible for $25,000 payments under the program are current Evanston residents who identify as Black or African American and were at least 18 years of age between 1919 and 1969. Evanston refers to this group as ancestors. To date, the city has approved payments to 141 ancestors, and at least 129 have already received payments. The second group of persons eligible for $25,000 payments under the program are individuals who identify as Black or African American, are at least 18 years of age, and have at least one parent, grandparent, or great-grandparent who identifies or identified as Black or African American, lived in Evanston between 1919 and 1969, and was at least 18 years of age at the time. Evanston refers to this second group as direct descendants. A direct descendant is not required to be a current Evanston resident to receive a payment. At no point in the application process are persons in the first and second groups required to present evidence that they or their ancestors experienced housing discrimination or otherwise suffered harm because of an unlawful Evanston ordinance, policy or procedure, or some other unlawful act or series of acts by Evanston between 1919 and 1969. In effect, Evanston is using race as a proxy for having experienced discrimination during this time period. A third group of persons eligible for $25,000 payments under the program are current Evanston residents who are at least 18 years of age and can show that they experienced housing discrimination after 1969 because of an Evanston ordinance, policy, or procedure. Unlike the first and second group of recipients, Evanston does not expressly use race as an eligibility requirement for this third group. On March 27th, 2023, Evanston expanded the program to include an option to receive a direct cash payment. As of October 5th, 2023, Evanston was still verifying direct descendant applications, including applicants' ancestor information. By January 11th, 2024, Evanston had approved 454 direct descendant applications, but had not made any payments to the approved applicants. The city has represented that all 454 will receive $25,000 each. On or about January 11th, 2024, Evanston randomly assigned selection numbers to the 454 approved direct descendants to determine the order in which the payments will be made. Evanston anticipates making $25,000 payments to at least 80 approved direct descendants in 2024. The remaining approved direct descendants presumably will be paid sometime after 2024. As of May 1st, 2024, the city had met with 70 of the 80 direct descendants who are most likely to receive payments in 2024. Some 60 of these direct descendants opted to receive a direct cash payment. At all relevant times, plaintiffs satisfied and continue to satisfy all eligible requirements for participating in the city's program as direct descendants, other than the race requirement. At all relevant times, plaintiffs were able and ready to apply for payments under the program and will be applied, but for the program's race-based eligibility requirement, plaintiffs remain able and ready to apply for payments under the program and intend to apply if the race-based eligibility requirement is declared unconstitutional and enjoined. But for the program's race-based eligibility requirement, plaintiffs would be in line to receive $25,000 direct cash payments as, quote, direct descendants, quote. Class allegations. Plaintiffs bring this class action under Rule 23 of the Federal Rules of Civil Procedure. The class includes all individuals who are able and ready to apply for the program and are eligible for a $25,000 payment, but for the program's race-based eligibility requirement. The class is so numerous that joinder of all members is impractical, as plaintiffs estimate that given the 50-year time period covered by the program and the city's population during that period. The number of members is in the tens of thousands, if not more. There are questions of fact and law common to all class members, as each member is eligible for a $25,000 payment, but for the program's race-based eligibility requirement, which violates the Equal Protection Clause of the 14th Amendment to the U.S. Constitution. Plaintiffs' claims are typical of other class members, as Evanston is discriminating against each member on the basis of the member's race, in violation of the Equal Protection Clause to the U.S. Constitution. Plaintiffs fairly and adequately represent the interests of the other class members, as each class member is eligible for a $25,000 payment if Evanston's race-based eligibility requirement is declared unlawful and enjoined. A class action can be maintained because prosecuting separate actions by individual class members would create a risk of inconsistent or varying adjudications with respect to individual class members that would establish incompatible standards of conduct for Evanston. Prosecuting separate actions by individual class members also would create a risk of adjudications with respect to individual class members that, as a practical matter, would be dispositive of the interests of the other members not parties to the individual adjudications. A class action can be maintained because Evanston has acted on grounds that apply generally to the class, so that the relief sought is appropriate for the class as a whole. A class action can be maintained because the questions of law or fact common to the class members predominate over any questions affecting only individual members. A class action is superior to other available methods for fairly and efficiently adjudicating the controversy because all class members are subjected to the same equal protection violation, and but for Evanston's racial discrimination, all class members will be eligible for a $25,000 payment. All right, count one, equal protection. Plaintiffs reallege paragraphs 1 through 32 as if fully stated herein. Defendants' use of race as an eligibility requirement for a payment is an express policy or widespread practice so permanent and well settled that it constitutes a custom or practice for purposes of municipal liability under Monell versus Department of Social Services. Plaintiffs enjoy the right to equal protection of the laws as protected by the Equal Protection Clause of the 14th Amendment to the U.S. Constitution. Defendant acting under color of law is depriving plaintiffs of their right to equal protection by purposefully and intentionally discriminating against plaintiffs on the basis of race. Defendant's use of race as an eligibility requirement injures plaintiffs because it is a barrier that prevents plaintiffs from participating in and obtaining payments under the program on an equal footing with persons who are able to satisfy defendant's race requirement. Plaintiffs also are injured by defendant's use of race as an eligibility requirement because, but for the requirement, plaintiffs would each be eligible for and in line to receive $25,000 under the program. Defendant's use of race as an eligibility requirement is presumptively unconstitutional. Adarand Constructions, Inc. versus Peña. Defendant's use of race as an eligibility requirement cannot survive strict scrutiny. Among other reasons, defendant has not identified a compelling governmental interest advanced by its race-based program. Remedying societal discrimination is not a compelling governmental interest. Richmond versus J.A. Croson Company. See also Regents of University of California versus Bakke. All right, describing societal discrimination as an amorphous concept of injury that may be ageless in its reach into the past. Remedying discrimination from 55 to 105 years ago, or remedying 150 years ago, or remedying discrimination experienced at any time by an individual's parents, grandparents, or great-grandparents has not been recognized as a compelling governmental interest. Defendant also has demonstrated that his actions between 1919 and 1969 constituted a prima facie constitutional or statutory violation of anti-discrimination laws in effect at the time, let alone provide a strong basis in evidence that remedial action is necessary 5+ decades, if not more than a century later. Richmond, 488 U.S. at 500. Defendant also has not and cannot demonstrate that its use of a race as an eligibility requirement is narrowly tailored. Among other shortcomings, defendant's use of race as a proxy for experiencing discrimination between 1919 and 1969 does not limit eligibility to persons who actually experienced discrimination during that time period, and therefore is over-inclusive. Defendant also failed to consider race-neutral alternatives, such as requiring prospective recipients show that they or their parents, grandparents, or great-grandparents actually experienced housing discrimination during the relevant time period because of an Evanston ordinance, policy, or procedure. Very interesting. As defendant requires for the third group of prospective recipients. Nor did defendant take into account race-neutral anti-discrimination remedies before adopting its race-based eligibility requirement. Plaintiffs are being irreparably harmed by defendants' deprivation of their rights to equal protection and will continue to be irreparably harmed unless defendants' use of race as an eligibility requirement for the program is declared unconstitutional and enjoined. Plaintiffs have no adequate remedy at law, wherefore plaintiffs, individual and on behalf of class members, respectfully request that the court 1. Declare defendant's use of race as an eligibility requirement for participation in the program to be unconstitutional. 2. Enjoin defendant from using race as an eligibility requirement. 3. Award payments to all eligible individuals. 4. Award plaintiffs attorneys' fees and other litigation costs reasonably incurred pursuant to 42 U.S.C. 1988. And 5. Grant plaintiffs other such relief that the courts deems just and proper. Plaintiffs demand a jury trial dated May 23rd, 2024, respectfully submitted. All right, and there's information on the counsel for plaintiffs. Judicial Watch Incorporated and Chalmers, Adams, Bakke, and Kaufman, LLC. Here are some terms and definitions. Injunction: an authoritative warning or order, a judicial order that restrains a person from beginning or continuing an action threatening or invading the legal right of another, or that compels a person to carry out a certain act. Example, to make restitution to an injured party. Enjoining: to prescribe a course of action with authority or emphasis. The doctor enjoined a strict diet to direct or order to do something. Injunction and enjoining was used in the following. Plaintiffs also seek an injunction enjoining defendant from continuing to use race as a requirement for receiving payment under the program and requests that the court award them and all class members damages in the amount of $25,000 each. Joinder: the action of bringing parties together, union. The joinder of parties. In law, a joinder is the joining of two or more legal issues together. Procedurally, a joinder allows multiple issues to be heard in one hearing or trial and occurs if the issues or parties involved overlap sufficiently to make the process more efficient or fairer. Joinder is used as the following. The class is so numerous that joinder of all members is impractical, as plaintiffs estimate that given the 50-year time period covered by the program and the city's population during that period, the number of members is in the tens of thousands, if not more. Adjudications, a formal judgment on a disputed matter. Adjudication is the legal process by which an arbiter, a person who settles a dispute or has ultimate authority in a matter, or judge reviews evidence and argumentation, including legal reasoning set forth by opposing parties or litigants, to come to a decision which determines rights and obligations between the parties involved. Adjudications was used in the following. A class action can be maintained because prosecuting separate actions by individual class members would create a risk of inconsistent or varying adjudications with respect to individual class members that would establish incompatible standards of conduct for Evanston. Dispositive, deciding a matter finally or relating to the process of doing this. Example, the trustees have a dispositive power to transfer the money. Dispositive was used as the following. Prosecuting separate actions by individual class members also would create a risk of adjudications with respect to individual class members that, as a practical matter, would be dispositive of the interests of the members not parties to the individual adjudication. Presumptively, used to show that something is believed to be true based on the information that is available. It seems that under the guidelines, the merger remains presumptively illegal. Presumptively was used as the following. Defendant's use of race as an eligibility requirement is presumptively unconstitutional. Prima facie, Latin, based on the first impression, accepted as correct until proved otherwise. Prima facie used as the following. Defendant also has not demonstrated that its actions between 1919 and 1969 constituted a prima facie constitutional or statutory violation of anti-discrimination laws in effect at the time. Here's some of the rules and cases that were mentioned for the City of Evanston reparations lawsuit. If you have a chance, you can do your further research on it. We will be putting links in the description box below of this video. Should we be concerned with the City of Evanston reparations lawsuit? Please leave your comments in the section below. Greatly appreciate it. Please like, share, and subscribe because we will be following the California reparations bills that are going through the California Assembly and then eventually will be signed by the governor. So thank you for your time and energy into this matter. And as always, I appreciate you staying informed. On that note, once again, please like, share, and subscribe, and hit that bell. Peace and reparations.